Okay, folks, we're live online and we're about to start. Um, all right, welcome. So my name is Michael Carroll. I'm a faculty co-director of our program on information justice and intellectual property. And welcome to the latest installment of our intellectual property at the Supreme Court series, which we've been running since 2012. We had a rollicking argument this morning, and we're going to want to discuss that. I'm going to just say I'm avoiding the slides because there's so much to talk about, but let me set up the case very briefly, and then I'll introduce our panelists, and then we'll get to the discussion. This case is a follow-on case from an earlier case, BMG versus Cox, brought before the Fourth Circuit. This is an unusual case because in that case, Cox is an online service provider, and under the Digital Millennium Copyright Act, online service providers enjoy safe harbor protection subject to certain conditions. In the BMG versus Cox case, the district court held and the Fourth Circuit affirmed that Cox had lost that safe harbor protection because it had not, quote unquote, reasonably implemented a repeat infringer policy. There were some other holdings involving secondary liability that the district court found and a jury found, but the Fourth Circuit rejected, and that case then settled after that. But this case then follows on because once the safe harbor holding had been made, it opened the door to the question that we'll discuss today, which is in the absence of safe harbor protection, can Cox be held liable as a contributory infringer for failing to terminate subscribers from about whom it had received notices that those accounts were being used for copyright infringement. So there were 163,000 notices during a 22-month period, 57,000 accounts, and about 10,000 copyrighted works. There was a jury trial that found Cox both vicariously and contributorily liable and awarded damages for willful infringement in the amount of $99,830 per work. When you multiply that by 10,000, you basically get $1 billion. The Fourth Circuit reversed the vicarious liability holding, but affirmed on a contributory infringement. And we are now facing the question whether the Fourth Circuit erred on that question. There's also an issue about whether the willfulness standard and the jury instruction was proper. We're not going to spend much time on the willfulness issue. It's really the standard for secondary liability, which has been opened up by this case. And I will just say that there are a couple of other things floating in the air that you'll hear about. One is that there were references to other secondary liability cases the court has recently heard in the Twitter versus Tomna case and Smith and Wesson, not copyright cases, but issues of secondary liability and common law secondary liability. And so there's questions about how much the court will be leaning on those other outside of copyright precedents to inform its analysis in this case. And the last thing I'll say is just the text at the Fourth Circuit that's under review is whether the standard for a material contribution to infringement is met if you have knowledge that infringement was, quote, substantially certain to result from the continued provision of internet service to these accounts that had been noticed. One alternative test that's available is the Ninth Circuit test, which would say the failure to take, quote unquote, simple measures to stop infringement could lead to liability. With that, I will then introduce our panelists and ask them then to give us, I'm going to give them each 5 minutes to say a little bit about the summary of their basic position before the court, but also because there was so much rich material in the argument, I've asked them to also comment on the way the court may or may not have responded to their arguments. That'll be one round, and then we're going to do, I've got a couple of big thematic questions, and then we're going to have an open discussion about this argument. So to my immediate left is Rebecca Tushnet. She served as counsel of record for the amicus curiae, or the amici brief filed on behalf of the ACLU of Virginia, and the Center for Democracy and Technology. She is the Frank Stanton Professor of the First Amendment and co-director of the Berkman Klein Center for the Internet and Society at Harvard Law School. She frequently consults with Lex Lumina, a leading firm in the intellectual property and First Amendment litigation. To her left is Ed Williams. He served as counsel for petitioners Cox Communication in this case. He's of counsel to Orrick, Harrington, and Sutcliffe's renowned Supreme Court and appellate practice. He focuses on complex appellate litigation, certiorari, and merit stage briefs before the Supreme Court, and is additionally the former director of the Howard University School of Law Civil Rights Clinic, an experience that continues to shape his approach to litigation today. To his left is, make sure I'm right, all right, Michael Allen, who authored an amicus brief on behalf of the National Music Publishers Association, the Recording Industry Association of America, and the Nashville Songwriters Association, and the International and Songwriters of North America in support of respondents. The members share an interest in promoting robust copyright enforcement against online piracy. And Allen is a partner, Michael Allen is a partner at Step 2, where he maintains a broad intellectual property practice and serves as chair of both the firm's copyright and trademark groups. To his left is Jacqueline Charlesworth. She served as counsel for on the brief for former members of Congress and registers and general counsels of the U.S. Copyright Office in support of respondents. They seek to ensure that U.S. copyright law, including the DMCA, is correctly interpreted. And she is a former general counsel of the U.S. Copyright Office and is now a partner in the litigation group of Frankfurt, Kernet, Klein, and Sells. And then last but not least is my colleague, Charles Dwan, who is an assistant professor of law here at American University. He authored his own brief in support of neither party, but I also asked him to do double duty because the United States never participates in our discussion. They don't comment on pending litigation. So I've asked him to step in and play the role of the United States government and tell us a little bit about what the Solicitor General argued to the court. Professor Dwan is a junior professor in terms of his rank at our law school, but he is a well-known writer of amicus briefs, having written over 200, and is one of the more winning, what did you say you are? The most winning?
Sixth winningest amicus counsel in, I think, 2014. Oh, I mean, that's not saying.
All right, great. Okay, so I'm going to ask Ed to go first since we have counsel for one of the parties. Sony's counsel was unable to join us. I will just very briefly say one or two things about the high point of their brief. I won't be able to comment on I won't speculate on their view of the argument. But I'm sure Michael and Jacqueline can fill in that blank. And then I'll just pick at random from there. But Ed, please go ahead.
So first, thank you to American for holding this panel and for inviting me and folks to come and talk about the case. Today was obviously a riveting argument. Our arguments were obviously laid out in our brief, and I know that most of the folks here are well read and understood, but I'll just highlight a couple of things from them and then talk about how I think they played an argument. So obviously on the first question presented, our task was to try to help the court understand how this case situates itself in the context of aiding and abetting or accomplice liability more generally. What does it actually take to be an accomplice in the context of copyright infringement or for secondary liability? And we look not just to copyright cases. You obviously have two. You have Sony and Grokster, which really are laying the foundation. And Grokster is an inducement case, and that case is a follow-on to services that I was alive and well and thriving and using to some extent when I was a kid, but like LimeWire and Napster and the like. And obviously that was a software that was designed specifically for the purpose of being able to help you to infringe, to be able to trade things that you weren't buying from somebody else. This is also back in the day for CDs, and when you actually you would listen to the radio and record something on a tape recorder. So there was technology was very, very different then, which is also a unique issue in the case for the court to grapple with. So in that context, that technology is very different, and we need the court to understand what aiding and abetting liability should apply here. We looked to other aiding and abetting liability cases like Twitter and Smith and Wesson more recently to try to situate the court. And so in those cases, and Twitter in particular, the court does kind of a full treatment of aiding and abetting liability of those principles. And we say, look, it takes knowledge, but it also takes something else. And we borrowed from Grokster a sentence that says that the something else is affirmative culpable conduct. And what is culpable conduct? Affirmative culpable conduct is conduct that demonstrates that you want the thing to happen. You want the infringement to occur. And obviously from my perspective, I know I'm going to be disagreed with by others on the panel. Your internet provider doesn't care if you infringe. This is during argument, Josh Rosenkrantz, partner at Oracle, who argued the case this morning, kept using the term equivocal, something that is equivocal. That means we don't care if it happens. We don't care if it does. We don't care if it doesn't. That is not the type of act coupled with knowledge that lends itself to accomplice liability. And we would say that's true in generally as an aiding and abetting principle. Twitter, Grokster, Sony, Smith and Wesson teach that. So that's kind of the general idea and what we're trying to persuade the court of. How I think it went, I think that it's very likely that the court is going to reverse. I think that it's very likely that, but I also don't, I think the court thinks the Fourth Circuit got it wrong, but I think that they're not sure why. And so the conversation, I think, is kind of going to be about what exactly is it that the Fourth Circuit should have done differently to get to some differing results, right? So our answer is that the Fourth Circuit got it wrong because they only focused on knowledge and then treated the continual provision of service as an affirmative culpable conduct, and it's not. It's just a continuance of providing a generally used, many use service into the stream of commerce. But I think that there are a couple of different ways the court might approach it. And here's, kind of, if I were thinking about today, based on how I'm feeling today, having not really fully processed probably all of it, how I think an opinion might write. You start with the fact that secondary liability is not in the Copyright Act, right? And that came up at least twice, maybe 3 times in the argument. So what do you do in a situation when the statute does not authorize the cause of action? Well, then you have an implied cause of action. This court, as a conservative court, generally is hostile to implied causes of action. I'm sure that there are many examples of this. Bivens comes to mind, obviously, as an implied cause of action that conservative courts are incredibly hostile to. And so then you limit how far you're willing to let that cause of action go because it's not in the statute. And then the question is, what's the proper limitation? And this is where I think the conversation gets really interesting because I'm not actually sure what the court will do here. So one angle is to just say its purpose, to agree with us that it's purpose, and then not say anything more about what that is, or at least maybe 2 votes for that. There might be a vote for we should just do what we did in patent because that's how we got here in the first place, right? So the patent statute does actually detail what we could argue are 2 ways of meeting the purpose or provision or purpose element. So maybe there's a vote for that, or vote or 2 for that, and then maybe there's a vote or 2 to go all the way with us. That it's that purpose requires that is precisely the type of conduct that we were trying to persuade the court of in our brief and our argument. And then I think if there is a dissent, it's at most 2 votes on the dissent. If I had to guess right now, I could see a lone dissent even in the case, or I could even see a concurrence in part and dissent in part. I think this is actually it could be more fractured than I think we thought it might be going into the case. So
great, that was great. Thank you so much. So again, I'm not Sony, and I don't want to misrepresent their position. I will say, so quoting from their summary of the argument in the brief, I think the court was looking from counsel for a standard. What is the standard? And I think Ed just offered Cox's standard. Sony offered the court a standard that says when providers offer an ongoing service and obtain affirmative evidence of its unlawful use by particular users, then it cannot ignore that without and avoid liability. So it's Sony's brief is very the opening is, look, Cox just wants to tell you that they are providing a neutral service and that they're, the fact that they get noticed shouldn't be material legally because they're just providing this service in the same way that Sony was providing the Betamax back in the day. And you should be relying on the Sony case as essentially mapping onto these facts. And Sony argues in this case, oh no, we would agree that if all you were doing was providing a general purpose technology, we wouldn't have sued you. It's instead that you had all of these repeated notices about particular accounts and chose to take no action in response or very little action according to Sony's position. There's a lot in the record about the specifics of this case that were not great facts for Cox. But including a manager who, quote, said, F the DMCA. And this is someone inside the compliance unit. But that is sort of by the by in the sense that the job for the court is really to offer us a general standard. One other point that came up a lot in argument is just what is the relationship between what the court says in this case and the safe harbor provision under the DMCA? Sony took the position that if Cox is not held liable on these facts, then the DMCA is basically a quote unquote dead letter because why would anyone feel like they needed to comply with safe harbor protection if there was no liability risk sitting behind that? And so that was a big point in the argument with Sony, but I won't say any more about that. I regret that we don't have their counsel with us. Charles, because the government also got a chance to argue, let me ask you to tell us a little bit about that. And then I think what I'll do is ask Michael, Rebecca, and Jacqueline.
Sure. Thanks. And delighted to be here. So I'll talk a little bit about my brief and also about the government's brief at the same time because they were actually reasonably somewhat overlapping in subject matter. I would also like to thank my research assistant, Joe Rios, who helped me deliver the brief to the Supreme Court in the middle of the pouring rain, which occurred the day before the deadline for the briefs. Both of us got soaked. I have a very wet copy of my brief sitting up in my office. But students at WCL have a lot of dedication. Wonderful. As many of you know, I teach patent law. And sticking true to my beliefs, I filed a brief about how patent law fits into this copyright case. Why does patent law fit into a copyright case? And I would say for two reasons. At base, this case is about what happens when a company has knowledge of infringing activity and also provides some sort of generic service or product to that person. And that's a situation that can come up in copyright law, but it can also come up in patents. One example in a case that I've been following fairly closely, this is a case called Ameren versus Hickmo, which is, I believe, still on petition at the Supreme Court, involves generic drugs. You can have a generic drug manufacturer who knows that the drugs will be used to treat a condition where the use of that drug for treating that condition is patented. The drug itself is off patent, but using the drug for a certain purpose is patented. The generic manufacturer sells the drug. The drug is a generic product, sort of like the internet service here, which can be used for infringing purposes or not. And the company has knowledge that this drug might be used for that infringing purpose. And so that overlap struck me as an interesting relationship and prompted me to think about how this case fit together with patent law. The first thing is that the courts dealing with patent issues have often drawn from copyright cases to decide the scope of secondary liability in patent law. So Grokster, one of the primary decisions on secondary liability in copyright law, has been cited all over the place in patent cases. Numerous courts have relied on the statements that the court made with regard to copyright law for inducement of copyright infringement to interpret the patent statute. And so to the extent that the court makes some sort of ruling in the Cox case, that probably translates over to patent law. That seemed like something that would be worth the court being aware of because its decision might have these larger implications. And I think you saw that quite a bit during the argument, in which the court was thinking not just about the implications for copyright law, but more generally, if we're going to announce a rule about accomplice liability, how does it affect torts? How does it affect patents? How does it affect a lot of different areas? The court has long been keenly aware of these sort of larger potential implications, and certainly was thinking about it here. The second reason that patent law is interesting is that in determining the scope of secondary liability in copyright law, the court has regularly referred to patent law. Grokster itself drew its doctrine of inducement of copyright infringement from the patent statute. Sony drew its doctrine of contributory liability and its doctrine of substantial non-infringing uses from the patent statutes. And so patent law serves as a really useful basis for understanding how secondary liability ought to work more generally within intellectual property law. And this is sort of where the overlap with my brief and the Solicitor General's brief come in, because sort of toward the early 1900s, you had a fair number of cases on secondary liability for patents, mostly in the context of tying products. So there was a mention of the Henry versus A.B. Dick case. That was a case in which you had a mimeograph device. The mimeograph device was patented, but and so the company wanted also to have exclusive rights over selling the ink that was used with the mimeograph machine. And so when somebody else started selling the ink, the patent holder said, hey, you're not allowed to sell the ink because that would be contributing to somebody else's infringement of our patent. Those precedents ended up influencing the development of secondary liability in copyright. In copyright law, the court mentioned the Kalem case, and obviously the Sony and Grokster cases both rely on this line of historical precedents regarding patent law. The lesson that I draw out of those early patent cases, and that the Solicitor General tended to agree with, is that in order to have secondary liability under patent law, there has to be conduct that is specific to the infringement. Some sort of generalized conduct that happens to help with the infringement isn't sufficient. The conduct has to be targeted toward the infringing act. And during the oral argument, Malcolm Stewart repeatedly said targeted conduct. He really wanted targeted conduct to be sort of the rule by which the court determined what was necessary in order to find secondary liability. So I think that was the message that I was trying to put forward during in my brief. The Solicitor General generally seemed to go along with the same sort of theory that you need some sort of very specific conduct relating to the specific act of infringement. And I think that was one of the reasons why the court spent a fair amount of time talking about patent law, among other things such as tort liability in the DMCA, in trying to solve this puzzle of how do we interpret the scope of secondary liability when the statute doesn't give us that sort of specific guidance.
Great. And I realize I'm calling on the men first, but Michael has special knowledge of the facts of this case. So I wanted to ask him to chime in first, and then Rebecca, and then Jacqueline. Go ahead.
Great, thank you. Well, today was a very interesting day for me because this has been quite a journey. It was 11 years ago we filed the very first case against Cox for BMG. And I was the one that found the famous, or now infamous, F the DMCA email. And I actually think I deposed that person, if I remember correctly. So I was listening very intently to the argument today for all of these various issues. I also argued the first Fourth Circuit case, but the facts were not discussed. And there's so many interesting facts in this case that I think was mentioned are not very good for Cox. I don't think there's really much of a debate about that. But let me talk to you a little bit about the brief we put in for the Recording Industry Association of America and the National Music Publishers, a couple of other trade groups. So we basically had three kind of main components of our brief. The various briefs spelled out this lively debate about the standard that we're engaging in today. But what we wanted to do is make clear to the court that, historically, the music industry, and not just the music industry, but in a lot of cases, the music industry has relied on common law secondary liability concepts and legal opinions to protect its rights throughout the years. This goes back decades, right? And you heard, if you listen to the argument today, you heard a lot of discussion about older cases, some going back to the 1800s. The Henry v. A.B. Dick case, I think, was 1911 or 1912. These various dance hall cases that were discussed were in the 40s, 50s, and 60s, and so on. There's a bunch of swap meet cases. And so, you know, the reason why I'm sure everyone, I mean, the reason why I like intellectual property law is you take existing new technologies and you apply it to old law. That's what we do, right? And so, even though the internet and certainly peer-to-peer file sharing were around when these cases were decided many, many years ago, they provide the backbone of sort of why we're here today and why the case was brought. Some of the people on this stage, thank God, is responsible for these activities. So we wanted to make it clear to the court that this is based on well-settled, established jurisprudence. You're right. The Patent Act has a codified statute. The Trademark Act, which is inducement only, by the way, the Trademark Act has a little bit of a nuanced description, but the notion of contributory liability in the copyright context, which was first enunciated in the Gershwin case, probably back in, I'm getting my dates wrong, maybe 71 or 72, was knowledge and material, you had to have direct knowledge of the infringement and material to that infringement. And so we thought it was important to explain this kind of frame, which is a big part of our brief. Secondly, you know, we focused on the DMCA, right? And the DMCA was enacted in 1998. And it was the very beginning of the internet. We didn't have mass online infringement, certainly the way that we do now. We didn't have peer-to-peer networks. And the way that digitized assets can be used in unauthorized ways was not anywhere near where it, you know, in the infancy of the internet that it is now. Nevertheless, Congress saw fit, and they sort of saw ahead, and they realized that there were some changes that needed to be made, and that there was certainly a risk of infringement along these lines. And there was some discussion of this at the argument today. And Congress enacted a safe harbor to allow intermediaries, service providers, just like the ISP in this case, a way to get out of jail free. If you did certain things, you developed a policy to terminate repeat infringers in particular circumstances and appropriate circumstances, you couldn't be held liable. And so explaining that background and the reasoning behind it and talking about the congressional intent behind it was a big part of our brief. And there were a couple of points where this came up in the argument today. It may have been Justice Kagan, but I think a few people were asking petitioners counsel, look, if you win, if Cox wins and we side with you, what do you have to do? I mean, do you have to do anything? And there was sort of an acknowledgement that, you know, no, they don't have to take these notices. They don't have to deal with doing anything with respect to infringement on their network. It's just unnecessary. And I thought that was quite telling. And, you know, another issue that came up, or a line of question that come up more than once, was, well, if Cox wins, if the Supreme Court sides with Cox, then what's the point of the safe harbor? Why? I mean, are we to just ignore this congressional intent that's 25 plus years old? I mean, if an ISP under these facts cannot be liable, why is there a safe harbor? And don't we need to give some credence to the fact that there is one? At least Congress in 1998 recognized that there could be liability. You know, so I think that was a very interesting, and there were a few different lines of questions on that. We also, I guess the third point is we wanted to point out that this was not sort of a shoot first, ask questions later type case. I think the notion was presented that, you know, these cases were filed. There's been a dozen or so of these types of cases that have been filed. And this was not a shoot first, ask questions later type scenario. We wanted to point out that the industry spent a lot of time, right, trying to work with service providers to find a solution to this problem. There have been educational efforts. There have been efforts to deter infringement online. There's been this entire copyright alert system, which is this program that a few different ISPs and a few larger content companies agreed to several years ago that is now defunct. There's been a lot of effort to try to solve the problem. And despite those efforts, what we were seeing, and in the industry was seeing, was, infringement on a still pretty significant scale, right? And the facts weren't really discussed today, but there are notices of, the same subscriber, the same IP address, getting notices weekly, monthly, yearly, every day for years, and nothing's being done about it. And so at some point, you file a case, and that's what happened here. And so I think that's kind of what's and so we wanted to point those three things out, which really weren't fully developed in the record. I do have a couple of other comments about the standard and that sort of thing, but I think that'll come later. So
well, good, thanks. All right, and Rebecca, tell us a little bit about what your brief said and what you how receptive an audience you think your arguments got today.
Hello? Uh-oh.
Here, you just use this.
Okay. Yeah, thank you. All right. So I'll try and be a little quick. So this was a brief for the ACLU, whose concern is mostly about freedom of speech in general. And our theory of the case was that the court was not going to want to treat copyright specially. And so it made the most sense to focus on general principles of common law liability. And that does seem to have been a generally shared view among the major players. It is not clear that copyright exceptionalism was missing from the oral argument, but it certainly wasn't the only thing on display. So the basic claim of the amicus brief is that failure to terminate a subscriber after notice of past infringements at that address isn't enough for secondary liability. It does not distinguish the electric company, the maintenance or janitorial company, and other essential service providers. It is just too far. And this is a thing that you can do with the common law, which evolves to recognize the different characteristics of different situations. And I will just say this, the electric company should never be required on pain of contributory infringement liability to stop providing its services to one customer if it is providing the same service to every paying customer because of accusations of infringement at that customer's location. I'm actually totally comfortable with that result, and I'm actually pretty comfortable with it for the ISP too. It is nice to see at the oral argument that we had at least one justice point out that relying on the goodwill of either huge company on either side of this case to behave well without some legal constraint, that's not necessarily going to go well. It's not as if the risks are one-sided here. And given cross ownership, actually in these industries, it's probably not, things are probably worse on the ISP side in terms of making mistakes or punishing customers because of fears of $150,000 a pop liability. So relatedly, the brief argues that the special characteristics of the internet should be taken into account in applying the common law test. So many of the analogies that we heard, and unfortunately we did hear them at oral argument, do not recognize some key facts here. And of course, this is the classic issue of reasoning by analogy. You have to make sure you got the analogy right. So, for example, there were analogies to a classic trademark case. So the manufacturers provide generic medicine to pharmacists. Some of the pharmacists may put the generic into a branded bottle and charge consumers the markup. That's trademark infringement. Everyone agrees. And the standard is if you know that a particular pharmacist is going to do that, then yes, you can be contributorily liable for that. But knowing that some pharmacists are going to do it is not enough. So the description of internet access as a technology with substantial non-infringing uses isn't really enough to explain what the internet is. First, and this is something that is the ACLU's primary concern, the speech consequences of cutting people off from internet access are much more significant than the ordinary business consequences of saying, I'm not going to supply you with the generics anymore. And the Supreme Court in its previous Packingham case made the point that to be a person in the world, right, to sort of get where you're going in America, internet access is pretty important. And that there was some discussion at the oral argument of, well, what is a university supposed to do? And apparently they're supposed to, give you mobile, really degraded internet access so that you can't possibly infringe. So, EduRoam, which I'm on now, should not be allowed because someone somewhere is going to use it to infringe. The other thing is that internet access is just much more of a general purpose technology than a VCR or generic drugs that have lawful and unlawful uses. Because of the special multi-purpose nature of internet access and its relationship to speech, we should be particularly hesitant before creating rules that impose liability on conduits.
This is live, by the way, so we can switch back. Great, and Jacqueline, go ahead. It's got a little lag. You push the button and then it comes on.
Okay. Well, I'm going to pose it up to you. Thank you for having me. And it was an interesting argument. The brief that I authored was on behalf of former members of Congress and heads of the U.S. Copyright Office and general counsels of the Copyright Office and people who were responsible for enacting the DMCA and also administering parts of the DMCA. So a lot of the ground that we covered, I think, was pretty similar to what was in Michael's brief. The point was to educate the court on, the roots of contributory liability, how it's been treated in the past, and in particular, Congress's purpose and intent, to use two words that were used a lot today, in enacting the DMCA. What was Congress thinking? And I don't think it's an understatement, and I think it was pretty much conceded or acknowledged by Cox that if you adopt the standard that they're advocating for, that there would be very little, almost no incentive to cooperate in the way Congress intended when it enacted the DMCA. The concept there, and there was an important early case called Netcom, where a computer bulletin board was found liable, potentially contributorily liable, for failing to take down infringing content when it received a notice or notices. And that was concerning to the nascent ISP community, and understandably so. And when Congress looked at that problem, they didn't say, okay, well, let's change the rules of contributory liability. They explicitly did exactly the opposite. They said, we're going to let that rule lie. In other words, the Netcom rule continue to exist. We're not going to mess with that. What we're going to do instead is create a safe harbor. So if you're running if you're an online service provider, you can, if you abide by some basic rules, you have a safe harbor from monetary damages. And there's very much a balance involved in that system. And it depends on the traditional rule, which is over 100 years old, of material contribution liability. So that's why this case is of particular importance, not just to the music community, but to all communities that want to be able to distribute their works online. And I will add here that, for example, YouTube, which was, obviously an early player here, has a whole very elaborate ecosystem that's developed under the DMCA. A lot of it was voluntarily put in place, but it's a way of managing infringement, which is ongoing, continues to this day. And what you have is a notice and takedown system, in some cases more elaborate, as in the case of YouTube, or simple DMCA notices. And without that system, it's a little hard to imagine how there'd be any kind of control over the potential for rampant infringement. And it's interesting, there's a footnote in Grokster that actually mentions that the Supreme Court did say, you have to sue the pipe sometimes. And that's what this case is really about. It's about the ability to deal with infringement, mass infringement at a level that makes sense, that's actually viable for creators and content owners. Speaking of Grokster, another point that our brief made, and Grokster came up a lot in the argument today, it came up a lot in the briefing. It was a little surprising to me because it was almost like the Cox position is the standard was set in Grokster. The standard for contributory liability was set way before Grokster, and Grokster, which I remember when it was being litigated, the big issue in Grokster was, unlike Napster, which had a centralized index, so there was knowledge, so Napster was contributory liable, you had a system that was decentralized, so there was no central index. So the big quandary in the Grokster case, and what the Supreme Court had to address, was the fact that Grokster didn't have the knowledge piece, except at a very general level. They didn't know specifically what works for traveling through the system. And confronted with that fact pattern, and the fact there were a lot of bad facts in that case, similar to the Cox case, the court borrowed from patent law and came up with the inducement standard, but that's always been understood, at least in my mind, and I think the mind of many others, as a separate branch of contributory liability. It's an alternative to the traditional material contribution standard. So those were all points that we wanted to emphasize to the court. I do think that the court, and maybe we'll have more discussions later, we certainly heard a lot of concern about the incentives under the DMCA, especially with sort of an acknowledgement on the other side that no, there really wouldn't be much motivation to help remove infringing content. So I imagine that will play some role in the court's decision. I guess I'll leave it at that, and we can talk some more.
Great. And I think in the interest of time, I was going to do 2 structured thematic questions, but I really want to get all your thoughts about the argument. So let me just throw these out there as things you can pick from, but otherwise there were so many different moving parts going on. One is this idea of, the court is very aware that they will be making law. They do that a lot, but here's a chance to paint pretty broadly in terms of, and they're aware that there will be some spillover effects, and because they were referring to the Twitter case and the Smith & Wesson case. But so one question is, do they think in this case they will be writing a general standard of secondary liability, at least for the internet, across all kinds of different domains? And then if they're writing that test, what's it going to look like? And it appears there was a state of mind element will be required for secondary liability. But what is that state of mind? Is it having knowledge that there's direct harmful behavior? Is it intent to encourage or facilitate that behavior? Is it having the purpose? And a lot of intent and purpose got a lot of. So I'd love your thoughts on both the question of are they writing a general test, and if they are, what's the difference between intent and purpose? Why did that get so much play? And what do you think they're going to do? Those are all the things I want to know. You can say as someone who teaches copyright, and I teach secondary liability the way Jacqueline just laid it out, I know I'm going to have to change my slides next year. That's the one prediction I'm sure about. But thoughts?
Well, I'll share some thoughts. I do, as I mentioned, I do think the court is going to have some concern about the DMCA framework because it's just, it's was very clearly established with contributory liability in mind. In Grokster, it was interesting, as I said, they sort of looked at the facts and came up with a rule. I agree with you. I think they're looking for some kind of state of mind. I think that the Henry v. Dick case is very interesting. It talks about distributing something with the expectation that it'll be used to infringe, and that under the facts of that case, which involved selling ink for a patented product, the facts showed purpose and intent. So I'm wondering if, the facts of this case will actually, as they did in Grokster, kind of drive the court's rule a little bit in terms of how they evaluate it. Because I think someone, maybe you said that, Mike, the facts here, if this case doesn't illustrate where you could find contributory liability, what case, or maybe it was you, Michael, I apologize but what case would, I mean, if you're going to have the ability to, apply a doctrine of secondary liability to, as they said in Grokster, kind of hold the pipes responsible, or it's the only efficient way to control some of this behavior. What facts really could be that much more alarming or concerning?
Rebecca she's got an on-point response. Go ahead.
So I wanted that too, but I actually wanted to pick up on your point about the DMCA, because I actually thought that focus was surprising, in as much as the liability we're talking about here comes from the 1976 Act, not from 1998 when the DMCA was enacted. When I went to law school, it was pretty standard to say that later text does not bear on the meaning of earlier text unless the later text says it does. And I kind of feel like we've lost a bunch of tools of statutory interpretation we used to have when we thought about what Congress actually thought it was doing, as opposed to focusing only on the words it used. And although that, discomfort showed up in other parts of the discussion, I think it's actually the weakness of the court's current approach is actually highlighted by the fact that it didn't even notice that it was, reading backwards in ways that ordinary tools of statutory interpretation until recently would have told you not to do. And, relatedly, it's weird for the current court to borrow from the Patent Act when the Patent Act explicitly has secondary liability. And the court is sort of aware of that, but it thinks it's too late to change. So I guess we're stuck with that. You always could go back to a more rich account of statutory interpretation where you took purpose into account. But you would still do things like say, okay, what does the 1998 law say about the 1976 law? And it actually does say it's not supposed to touch the liability under that law. And so let me just lead into a quick point. The question is, if Cox is right, what's the point of the safe harbor? Well, first, it's the point of any safe harbor, to resolve expensive uncertainties. Right? By definition, a safe harbor is for people who, in many cases, should win when they get through the long process. Maybe some should lose. But we do the safe harbor so that the vast majority of people don't have to fight through the complicated standard. So I think that's important. Also, there are many kinds of intermediaries. So Ravelry is different from eBay, although they are both 512C intermediaries. Or wait, are they C or D? I can never remember.
C.
They're C. All right, D is search tools. Right. So, but frankly, a site that has, like New York Magazine has this buying guide, right? It's a 512D intermediary for that purpose. It's not, and Google is also under 512D. There can be lots of different possibilities under 512A. You certainly couldn't have known what was going to happen in 1998. So that's the point of the DMCA.
And it looks like you want to.
I'll pick up. So a couple of thoughts. The big problem with Sony's suggested rule, and I think this is hard for the court, but is that the upstream liability doesn't have an endpoint. Like, what's the principled stopping point? So Professor Session mentioned your electric company, right, which is necessary for you to run your computer so that you can infringe if you're an infringer. What about the operating system on your computer? What about Apple and Microsoft? They could easily patch a security update through to your computer to block BitTorrent. But I'm assuming capabilities that likely exist, right? But if the question is, if the only thing that is needed in order to create that kind of liability is that they know for sure that someone at your IP address is going to be, substantially likely to infringe, there's no way to, the notices that Sony sent, or the music industry sent, could be sent to any upstream provider of a service or product that helps someone ultimately infringe. This is the challenge. So if you accept that that's kind of a problem, a principal problem, like we start with ISPs because they are providing continuous service, where electricity companies are providing continuous service. If we'll do it because it's the internet. one of the problems with this is the internet is the court only takes these cases like every 20 years, right? It resets the rules every 20 years. And 20 years from now, I have no idea what technology we'll be talking about, right? But the internet, I assume, will probably be some part of it, but it could be a much smaller piece. There may be a much an easier way of connecting thoughts and ideas and connecting people, et cetera. So that's so I think that the court's trying to this is why I think the court's going to set a general rule to start, to get to the question. I think this is why the court's going to set a general rule, but I think the court has to be very concerned about upstream liability when it sets that general rule, which is why the knowledge alone rule is not likely to hold the day. So that's one kind of big general concern. The other one is that even today, so the first case, the BMG case was 11 years ago, which I believe slightly precedes Spotify, if I'm not mistaken, just about. In the modern era, I think everybody in here gets their music from 1 or 4 different streaming services. We no longer, get CDs. We no longer get tape recorders. That technology itself has evolved. And the reason, one, because it's easy, right? And we pay a subscription service and we don't need generally to infringe. So, this is not a kind of, I think there's been a lot of woe is me in this case generally, but the music industry, last year, if I'm remembering the record correctly, had record profits. Why? Because Spotify and Apple Music and et cetera exist, because we are getting our music through streamers. So how the technology is going to evolve is also something the court, I think, is trying to figure out and take account of. And so I think that these are, this is why this case is particularly complicated. The court needs to set a general rule. It needs to say in a principled way why either the internet is special or copyright is special. And I don't right now think that the court, or at least I didn't hear from any of the justices, how they might articulate that principle. Justice Sotomayor asked specifically, what is the principled reason for trying to use for it being the internet only rule or copyright only rule? And I think it's really hard to draw a circle around this piece of technology and try to forward that rule for another 15 or 20 years. Or maybe we'll just get more frequent copyright infringement cases, perhaps. I don't know.
All right, Michael.
Thanks. So let me just address a couple of the comments that I just made. So look, I think there is a marked difference between an ISP like Cox and the electric company, or the company that makes the software that people run on a computer, right? And this is part of the problem with the facts not really being discussed in the case. The internet service provider is anything but a quote unquote dumb pipe. They are the gatekeeper, right? They are the connection between the content owner, the copyright holder, and the direct infringer. All the direct infringer has is an IP address. The ISP connects the IP address to the subscriber. The IP address, and I've been involved in a lot of these cases, so I can't remember if this is specific to Cox, but in large measure, they know a lot about the activities of a particular subscriber, including whether or not they're using BitTorrent. To the extent they're using BitTorrent, they can identify the computer that they're using BitTorrent on, the time of day they're using. I mean, the amount of information that the ISP has about a direct infringer is staggering. The electric company has nothing. The Apple Computer Company has nothing. The people that make the source code or the software or the operating system, nothing. The ISP is clearly in its own category, which is why it's been named in some of these cases. Just to touch on the issue about streaming was alive and well, certainly not to the extent it is now. In our case, we tried the case in 2015. And that was a big issue that they pointed to, which is now it's very easy and cheap and reasonably priced, well, not cheap, but reasonably priced to acquire music through all these different platforms. But again, the facts show that people are still using BitTorrent at very significant rates, right? And the problem with BitTorrent, in particular, some of these peer-to-peer file sharing networks, is once the copyrighted material is gone, it's gone. Right? The content owner loses control over it. It can be shared, copied, distributed all over the world. It's a big issue. So just real quick, turning to the standard issue, because I found this to be fairly interesting. In some of the earlier cases I was involved in, the ISPs took the position that Grokster basically completely changed the standard and made contributory liability an inducement-only standard. And I think, as Ed mentioned, I mean, Grokster, I don't think anybody's going to dispute, was an inducement case. But Grokster clearly discussed Gershwin. I think it upheld Gershwin, talked about material contribution and the like. And now Cox's position, and I think this is what the court is going to wrestle with to some degree, is where is the daylight between inducement, which I think everyone understands is an element that you can use. If there's inducement, you can use that to establish material, you can use that to establish contributory infringement. But what's the other piece, right? And so that's where you heard a lot of the delta between the respondents' counsel and the petitioner's counsel today. And you heard petitioner's counsel talk about, you mentioned this just a second ago, I think it was culpable act. There's got to be some sort of a culpable act. And there was some language about there needs to be affirmative conduct directed at fostering infringement. And then the government's counsel used targeted assistance. And when I was hearing everybody talk about this, I couldn't help, what's the difference between that and inducement? To me, that's inducement. And so there's very little daylight between the standard that the respondents are proposing and inducement. And it's essentially being made to be an inducement case. So I don't know how the court's going to react to that or resolve it. And maybe I'm the only one who had that reaction, but sort of watching the evolution of the dispute over what is contributory liability and where does material contribution fit into it, to see something that is very sort of, almost like inducement. I think they're going to have trouble wrestling with that, but I'll turn it over.
Yeah. So Charles, why don't you start us on, because we have to wrap up now. So sort of closing thoughts and any predictions on how this is going to get resolved and who writes.
Best prediction is it's not good to make predictions around here. So I'll make a couple of observations on the argument, though. So one thing that you heard a lot during the argument was who's a good corporate citizen, and what does it mean to be a good corporate citizen, and what are the incentives that one rule or the other are going to make? And the court is very interested in this because they're always concerned about what is the fallout from their decision, both in the particular case and in the large context. And I think that the answer that they got, which is pretty typical for these cases that relate to law and technology and intellectual property, is it's very hard to tell because all of these systems are intertwined and could potentially interact in unexpected ways. This is something that we see in patent law all the time. When the Supreme Court was taking patent cases left and right, they often would ask these sorts of questions. And the result of those cases was always, let's try to pick some pathway that's cautious, something that sticks to a well-trodden path, something that's in the common law already. We understand how the rules work, and we're not going to overextend ourselves in trying to define what that rule is. So for example, in the eBay case, they say, hey, let's just do the thing we've been doing for injunctions in all the other cases. We'll just apply that to patent law. We'll try to make things consistent. I think you can expect that something similar is going to happen here. One thing that I did notice was that I believe that all counsel were asked, what if we just remanded and said, hey, you didn't use the right test, try again? But we don't actually tell them what the proper test is in full, right? And like, I think, this sounds a little silly, but we've seen that sort of pattern occur in a number of other cases that involve these sorts of law and technology issues. And I think it reflects this degree of caution that the court wants to exercise. Justice Gorsuch in particular mentioned a couple of times, hey, isn't Congress really in a better position to do this sort of thing? Shouldn't we be cautious when we're working in the face of these complicated technologies and active legislation? And so that's something that I think you can expect, at least based on some of their prior decisions in patent law and elsewhere, that they are aware of these sorts of larger potential consequences and will try to take some sort of cautious path in view of that.
Great. Other predictions?
I've figured out how to turn on my mic, so it's a good day. I agree they're going to, I agree, I think, with Charles, that I think they're going to try and adopt a standard. Whether they need to remand under that standard is a question. I think, right now we have the Gershwin standard, material contribution and knowledge. I think it wouldn't surprise me. I don't want to actually predict anything because, but it wouldn't surprise me if they say something like the knowledge has to be an expectation that your product is going to be used to infringe, and that amounts to purpose and intent, some version of that. And, then the question would be whether the facts of this case support that. But that wouldn't be, to me, a particularly surprising result in this case.
Yeah, I think that, as I said at the top of this, I think that the justices generally think that the Fourth Circuit got it wrong. I think they're just not sure how, or what they need to do next, right? And so I think, we're obviously hoping for, a very clear test that says that we're 100% right. I think that we're probably not going to get that on this case. But I do think we're likely to get closer to our standard. I don't see the court adopting a knowledge-only standard. I think it makes the court uncomfortable for reasons I just articulated. And I think that trying to figure out what purpose means, there's an interesting relationship that's happening in the conversation today about how you infer purpose, right? So that kept coming up. It's like, so if purpose is the test, fine. But then what types of things either demonstrate that purpose, or what types of things can we therefore infer the purpose from? I think that the challenge, what I'm concerned about as a practitioner, is that this is murkier territory, right? And I think that this is an area in which ISPs, the internet in particular, would like a clear line. Which, I think the line is probably closer to where we are as a general matter, but I think we want a clear line. And I'm actually somewhat concerned that what we're going to get is some kind of bifurcated, three-part concurrence or test that goes back to the Fourth Circuit, where we duke it out there to try to figure out what it means. And, and we are left with unclear rules for much longer than I think is actually healthy for developing technology. So that's a broader kind of concern about where I think it could go. We'll see. There'll be a conference. Maybe they'll be able to wrangle, 5 justices around a clearer, bright line rule, but I think that might be challenging.
All right, Rebecca, I'll give you the last word. And my apologies to the audience. I know Q&A, you're hungry for it. There's so much going on in this case and so many different ways it could go. So I acknowledge we have a lot of knowledgeable people in the audience who have a lot that could be contributed, but we're now hitting time. So Rebecca's going to get to say the last words.
Okay, well, we'll hang around for questions, I think. So I don't make predictions. I just want to say a couple of things. There can easily be multiple gatekeepers. The electric company is also a gatekeeper. There's no power. There's not going to be any infringement. More importantly, the not a dumb pipe argument assumes that knowledge should be enough to create liability, which is precisely the issue to be decided. So saying that they're not dumb isn't really helpful. If Sony wins, raise your hand if you think that Sony won't send notices to Apple and the electric company, especially since the ISP will happily hand over information about subscribers if that's what Sony says will avoid a lawsuit against Cox. Okay, got one. Awesome. And then I just want to finish out the implications of the argument that once a copyright is infringed on BitTorrent, it's lost forever. So the solution is for houses that have hosted past infringers to lose their internet access. That just doesn't seem like it addresses the problem. And new 15-year-olds with poor judgment are minted every day. So.
We're going to close, and I want to thank our panelists for their time, attention, and wisdom. We want to formally close, but we have a reception outside. The conversation can keep flowing. And thanks everyone for taking time to be with us. Let's see what they're going to do. All right. Thank you.